California led the nation by passing Assembly Bill 5, known as AB5, in 2019. This landmark law codified the Dynamex decision, making it much harder for companies like Uber, Lyft, DoorDash, Instacart, and other gig economy platforms to classify their workers as independent contractors instead of employees. As of 2026, despite ongoing legal battles, Proposition 22 litigation, and federal challenges, AB5 remains the law in California. According to the official California Legislative Information website at leginfo.legislature.ca.gov, AB5 applies the ABC test to determine worker classification. Under this test, a worker is presumed an employee unless the hiring entity proves three things. A. The worker is free from control and direction. B. The work is outside the usual course of the hiring entity's business. And C. The worker is independently engaged in an established trade. For Uber and DoorDash drivers, Part B is nearly impossible to prove because driving passengers or delivering food is the usual course of their business. This means most gig workers in California are legally employees entitled to minimum wage, overtime, workers' compensation, paid sick leave, unemployment insurance, and the full protection of California labor laws. Yet wage theft in the gig economy persists. This presentation covers your rights under AB5, how to identify wage theft, and how to fight back using the California Labor Commissioner's Office, PAGA, and private lawsuits. How gig economy wage theft works. Wage theft in the gig economy looks different from traditional employment. Uber, DoorDash, Lyft, and Instacart use algorithmic pay systems that drivers cannot easily audit. According to a 2022 study by the Economic Policy Institute at epi.org, gig workers nationwide lose an estimated 15 to 30% of their potential earnings to various forms of wage theft. Common practices include unpaid wait time at restaurants, unpaid distance traveled between deliveries, pay that falls below minimum wage after expenses, and deactivation that locks workers out of their earnings without final pay. Under California Labor Code Section 226.2, pay periods and wage statements must accurately reflect all time worked, including time spent waiting and traveling between gigs. If DoorDash pays you $3 for a delivery that took 40 minutes, your effective hourly rate may be $4.50, well below California's minimum wage of $16 per hour. That wage gap is wage theft, and California law entitles you to recover the difference. AB5 Deep Dive. The ABC test and what it means for gig workers. Assembly Bill 5, signed into law on September 18, 2019, changed the landscape for millions of California workers. The core of AB5 is the ABC test. Part A requires that the worker is free from the control and direction of the hiring entity. Part B requires that the work is performed outside the usual course of the hiring entity's business. Part C requires that the worker is independently engaged in an established trade. For Uber drivers, the argument is clear under Part B. Driving passengers is the usual course of Uber's business. A California Court of Appeal confirmed this in Lawson v. Grubhub in 2021, holding that delivery drivers perform work within the usual course of a delivery platform's business. According to the official California Department of Industrial Relations website at dir.ca.gov, workers who meet the ABC test are entitled to minimum wage, overtime, meal and rest breaks, workers' compensation, unemployment insurance, paid sick leave, and protection from retaliation. Prop 22's limits. Why the gig exception doesn't fully protect drivers. On November 3, 2020, California voters passed Proposition 22, backed by Uber, Lyft, and DoorDash, with over $200 million in campaign spending. Prop 22 exempts app-based drivers from AB5's ABC test, instead creating a hybrid category with some benefits. Prop 22 guarantees drivers 120% of minimum wage plus 30 cents per mile only for engaged time. Wait time, time between gigs, and time spent driving to a pickup location are not guaranteed. On August 20, 2021, Alameda County Superior Court ruled Prop 22 unconstitutional, but as of 2026, it remains in effect pending appeal. Drivers under Prop 22 are also not entitled to paid sick leave, paid family leave, state disability insurance, or unemployment insurance. Build your case. 3 evidence tips that win gig economy wage claims. Winning a wage theft case as a gig worker requires evidence. Your trip history in the Uber or DoorDash app can disappear if the company deactivates your account. Screenshots are your lifeline. Under the burden-shifting framework from Anderson v. Mount Clemens Pottery from 1946, Once you produce credible evidence, screenshots of trip offers, pay breakdowns, and time logs, the platform must produce its own records to rebut your evidence. Tip 1. Screenshot every trip offer and payout. Tip 2. Track your actual hours using a time tracking app. Tip 3. Save all platform communications, including deactivation notices. Under California Evidence Code Section 250, these digital records are admissible in court. Use the DLSE BO 500 form at dir.ca.gov/DLSE to file a claim. Your legal options: DLSE, PAGA, and private lawsuits against gig platforms. California law provides 3 powerful enforcement routes. First, the DLSE wage claim under Labor Code Section 98. File the BO 500 form. No lawyer needed, no filing fee. The DLSE can award up to $50,000. Second, a PAGA action under Labor Code Section 2698 allows you to sue on behalf of the state. PAGA bypasses mandatory arbitration agreements under Viking River Cruises versus Moriana from 2022. Third, a private lawsuit for misclassification, unpaid wages, and waiting time penalties. Major cases like O'Connor versus Uber have recovered millions for drivers. Attorney's fees are recoverable under Labor Code Section 218.5 if you win. Anti-retaliation. You cannot be deactivated for fighting wage theft. Fear of deactivation is the #1 reason gig workers do not file wage claims. But California law provides powerful protections. Under Labor Code Section 1102.5, it is unlawful for any employer to retaliate against a worker for reporting violations. Filing a DLSE wage claim or a PAGA lawsuit is protected activity. Under Labor Code Section 98.6, any employee who files a wage claim is explicitly protected from discharge. Under Labor Code Section 232.5, you cannot be prohibited from discussing wages with other workers. If you are deactivated after filing a claim, you can file a retaliation complaint within 1 year. Remedies include reinstatement, back pay, and up to $10,000 in civil penalties. Resources and action plan. Where to get help and file your wage claim today. Step 1. Start documenting immediately. Screenshot every trip offer and payout. Track your hours. Save all platform communications. Step 2. Contact the California DLSE at dir.ca.gov/DLSE to file a BO 55 red wage claim. Call the California Workers' Rights Hotline at 1-833-526-4636 for free advice. Step 3. Consult an employment attorney through the California Employment Lawyers Association at cala.org. Many offer free consultations. Attorney's fees are recoverable if you win. Step 4. Consider filing a PAGA claim or joining a class action. The statute of limitations is 3 years under Code of Civil Procedure Section 338. You can also file with the U.S. Department of Labor at dole.gov/HED. California recovered over $100 million in unpaid wages in 2024 alone. Your evidence matters. Your rights matter. Start today.